The next major statute in the context is the National Green Tribunal Act adopted in 2010. It is pertinent to note in this context that there were two other statutes adopted in 1995, that is National Environment Tribunal Act and the National Environment Appellate Authority Act 1997. And this National Green Tribunal Act 2010 replaces both these laws. Out of these two, the National Environment Tribunal Act 1995 never came into existence. So what we can see is that National Green Tribunal Act 2010 is the result of a long-term process after doing a lot of trial and error in this context. Now let's try to understand what has been provided under the National Green Tribunal Act. First, the exclusive it provides exclusive jurisdiction to the National Green Tribunal as far as these environmental matters are concerned. That means no other court can take cognizance of a case concerning environmental issues, and this is both in terms of its original jurisdiction as well as its appellate jurisdiction. And the only appeal that is possible from the decision of the National Green Tribunal is that appeal is permitted to the Supreme Court. And as far as liability is concerned, the applicable principle is that the statute says that the National Green Tribunal will apply no fault liability principle. It also says that the tribunal will apply the polluter pays principle. So, but beyond that, the National Green Tribunal does not provide any guidance as to whether there is any exceptions or what are the kind of criteria to be followed by the tribunal in terms of fixing the amount of compensation. And as far as while it is clear that the compensation in case of damaged or death of people, or damaged or injury to individuals, or damage to property, while it is clear that the compensation will go to concerned individual or group of individuals, whereas damage to environment is concerned, the National Green Tribunal Act provides that the money or the compensation in that context should go to the Environment Relief Fund, and the money is expected to be used for the overall improvement or protection of the environment. While these are the two major important things, it's also useful to look at Bhopal as a case study. This is perhaps one of the worst industrial accidents in India, perhaps one of the worst industrial accidents in the world, and then it may be useful to see how these issues on liability worked in the case of Bhopal litigation. Bhopal gas leak disaster happened in 1984, and the magnitude of this disaster was such that it affected so many thousands of individuals and it continues to affect people, it continues to affect environment. As far as from a legal point of view, the litigation was started immediately after the incident, and there are two important developments that needs to be remembered in the context of Bhopal litigation is the concept of parens patriae. That the central government adopted a legislation in 1985 called Bhopal Gas Leak Disaster Processing of Claims Act 1985. The purpose of this legislation was to apply the principle of parens patriae. Parens patriae means this is a principle that endorses or that allows someone else to proceed, or someone else to take care of the litigation on someone else's behalf, or in this case the central government took that responsibility to represent all Bhopal victims. So this is the place where through a legislation court applied this principle of parens patriae in Bhopal in Bhopal litigation. The purpose was to speed up the litigation process. Another major legal issue pertinent in the Bhopal litigation context is the forum non-convenience, because it's pertinent to remember that first the case was fought in the United States, where the headquarters of the Union Carbide was situated, and the case was rejected by the US court by citing this concept called forum non-convenience. This meant the court found the United States as an improper forum to decide the case, and to put it in a different way, the US court found the Indian judiciary or the forum in India as the appropriate forum to fight the case, and this is the context in which the litigation came back to India. And as far as the landmarks in terms of Bhopal litigation orders are concerned, on 17th December 1984 there was his first interim order which granting rupees 350 crores as the compensation by the District Court Bhopal. And this was subsequently, the interim relief was subsequently reduced to 250 crores by the High Court. And later on, when the issue reached before the Supreme Court in 1989, somehow under the auspices of the Supreme Court, the matter reached to a settlement. The matter was settled for $470 million US. And it's very interesting to note that the legal consequence of the settlement was, after the settlement, the Union Carbide and all its subsidiaries were absolved from all civil and criminal liability. It's very important to note that even the Union Carbide was, through this settlement, through the civil proceedings, the Union Carbide was absolved from criminal liability as well. And this obviously triggered a controversy questioning the propriety of the settlement that absolving the Union Carbide from all criminal liabilities also. And again, in the case of settlement, this was not a settlement after determining the liability of the company. But later on, apparently due to the controversy and challenge on the propriety as far as the criminal liability is concerned, in 1991 criminal cases were revived. However, in 1996, the Supreme Court diluted the charges against the Union Carbide and its officials, and the charges were diluted from culpable homicide to rash and negligent act. So overall, the scenario is, even though the matter was settled under the auspices of the Supreme Court, the misery continues. Even there are several reports, including a report from reputed organizations like the Center for Science and Environment. It says that the environment continues to be polluted, and the people continue to suffer, and even we can even witness that the Bhopal victims continue their struggle both at the state level as well as at the central level for justice. So that means what happened, even after 30 years, almost 30 years, people continue to suffer after this Bhopal incident, and this prompted the Supreme Court in 2012 to give direction to the government to address the continued misery, direction to the state government as well as to the central government to take adequate care in terms of removing wastes or sludges from the Bhopal site. So to conclude, what we can see is that even though we have a few statutes, even though we have established principles like whether it is strict liability or absolute liability, or even though we have these principles endorsed in various statutes, we still have some challenges. One is obviously this burden of proof. In order to determine liability, it is very important that the claimant should establish cause-effect relationship. But as I have already mentioned, in the case of environmental disputes, it is very difficult to establish cause-effect relation, especially when the victims are poor and vulnerable. It is very difficult, or it's extremely difficult for them to establish this cause-effect relationship in a manner that is acceptable for a court of law. In this situation, an important question is whether it is proper to shift the burden. That means it is for whether we can think about shifting the burden to the industries, and presumably they have technical expertise and scientific expertise as well as financial resources. So what about a scenario where the claimants just need to make their claims and the burden is upon the industries to prove that it is not their fault? And the second major issue is compensation. The pertinent question is how to fix or how to determine the quantum of compensation. There are a couple of theories in this context. One could be the principle of restitution. The idea is the compensation, the purpose of the compensation is to restate the possession as if nothing happened. And this is apparently more or less a principle which is close to this principle of restitution has been applied by the National Green Tribunal in a case, Ambuja Cements case in 2013, and where the NGT used the term appropriate compensation. In this case, the NGT relied on a calculation made by an expert committee. Apparently, the expert committee might have taken the actual damages cost. So another principle in this context is a deep pocket theory, which was introduced by the Supreme Court when it discussed the absolute liability principle. The idea is the more prosperous is the industries, more should be the quantum of the amount of compensation. Maybe a purpose of this idea of deep pocket theory is to create a deterrent effect of compensation on all industries. However, there are very few cases where it has been endorsed but there is one example is the Sterlite Industries case decided by the Supreme Court in 2013, where the court referred back to its 1986 decision and apparently relied on this idea of deep pocket theory and directed the Sterlite Industries to pay 100 crores as compensation. The last point is, I mean, while victims could represent or victims could argue their cases for damage to individuals as well as to their property, who will take care of the claims from or on behalf of the environment? What we can see from few cases is like, I mean, possibly the court will take or various committees that the court will be appointing to make to calculate the amount of compensation would include environment as a category, and some of these environmental statutes also provide explicitly that environment is a category where amount of compensation needs to be calculated against that category also. This is precisely what happened in the case of Ambuja Cements case decided by the National Green Tribunal in 2013, that where the court directed that the amount or the amount of compensation calculated on behalf of environment needs to be deposited in the environment relief fund, and it is for the proper authority to use that amount in the interest of environment. So, while these challenges continues to remain, I mean, what we can also see is that judiciary is trying to address some of these challenges in different ways. Thank you.